Okay, well, it's just after 10 o'clock, so should we make a start? Good morning, everyone. Really good to see so many people here today for this, which is the latest in our 5 and 25 series of webinars. And today we're focusing on tricky questions of evaluation and the lessons that we can learn from case law. A few quick introductions. I'm Jenny Beresford-Jones. I'm a professional support lawyer and public procurement specialist here at Reeve, and we're also joined today by my very close colleagues, Claire and Shailee, both of whom are principal associates and procurement specialists too. We work very closely together, as you can imagine. Just before we get started, I think everybody will know by now that we've got a good deal of procurement law reform coming up. The procurement bill is working its way through Parliament. I think they're now at the committee stage and just waiting to get going again with that after the summer break. And as and when there's a new draft of the bill, you'll be able to keep track of all of our materials on procurement law reform by looking at our website. We've got the link there, so procurementportal.com/reform. In terms of the session today, just a few points of housekeeping. Very warm welcome to you all, and thank you for joining us. If you've got any technical issues, best thing to do is to pop a note in the Q&A box at the bottom of the screen, and my colleague Sarah is looking after the technical side. She'll try and help you get connected. Any legal questions, do feel free to also put those in the Q&A box. We don't usually take questions live during these webinars because we try to keep them to a sort of half an hour time limit. But we'll try to come back to you as many of you as we can after the session, probably via a Q&A document. I should mention the session is being recorded and we'll circulate a copy to everybody afterwards, but be assured that only the panel speakers can be seen or heard on the recording. And then finally, assuming that the technology works, you should see a short feedback form at the end of the webinar, which should pop up on your screen. So if you could just take a minute or two to complete that, we would be really grateful. That really helps us to plan our future events. And on that, we have got another one of these planned, and I think it's going to be on the 9th of November. And if I'm correct, we're going to be talking about drafting public contracts, but we're firming up the invite for that at the moment, so look out for that coming round shortly. So I think on housekeeping, that was all I needed to say. And sort of helpfully, I think it's me who's up first to talk about the first lesson that we can learn from case law, and that is about drafting and disclosing criteria that can be understood by the RY and tenderer. And of course, this is an area that has generated a lot of interest in case law. Two cases particularly I'm going to talk about today, and I've put them on the slide there, and those are clickable links. So when you get your copy of the slides, if you really want to get right down into the detail of the law, you can do so and read the judgment. Here's a very old photo for you. If anybody's done any legal training or is legally qualified, you might know something about this, but it's a picture of the Clapham Omnibus, a Victorian photo. And I put it there to illustrate the concept that all of us lawyers learn early on at law school, which is the idea that the court takes an objective view of the situation by referring to something which is a fictional idea. And the first legal fiction in case law was, of course, the reasonable man on the Clapham Omnibus, which is taken to mean something like the ordinary reasonable person. So the court asks itself, what would the ordinary reasonable person have done in this situation? And then following the creation of the man on the Clapham Omnibus, there were other legal fictions of objectivity which came into being through case law, and many of them have entered sort of common parlance in language. So the right-thinking member of society, the officious bystander, the fair-minded and informed, observer. These are all sort of legal fictions, objective tests that the court has created. And in public procurement, thanks to the European Court, we have our very own legal fiction, which is somebody or something called the reasonably well-informed and normally diligent tenderer, and he or she or it was created by the SIAC case back in 2002, and his or her or its purpose was to provide the court with some sort of objective test by which to assess whether authorities have been sufficiently transparent in the way that they disclose their award criteria. So the SIAC case was about a tender for sewage works of all things in County Mayo in Ireland, and you can see it in the green there. And the criteria in this tender was stated to be most economically advantageous, and of course price was a part of that. And using a sort of mathematical formula, SIAC, who was the unsuccessful bidder who challenged, was the lowest price bidder. But one of the consultant engineer evaluators said, well, I think if you look at it based on ultimate turnout cost, I think the winning bidder would have the lowest price. And of course, SIAC was rather upset about this and said, well, you can't do that because you haven't said in your ITT that this is how you're going to evaluate price. And the Irish courts referred the question of how to approach this difficulty to the European Court. And the European Court, when it receives a referral like this, it doesn't give a judgment in the case itself, but what it does is set out the principles that the referring court should then go on to apply to the facts. And this is what the court said. And particularly, you can see there that they created the concept of the reasonably well-informed and normally diligent tenderer. So there are four things that the European Court said needed to be disclosed. So first of all, your criteria have got to be mentioned in your contract documents or your contract notice. You've got to formulate, which I think means write down, the criteria in such a way that allows all the R-wind tenderers, the reasonably well-informed and normally diligent tenderers, to interpret them in the same way. And then that obligation applies equally to the authority, who's got to interpret the award criteria in the same way through the process. And they've got to do so in a way which is objective and uniform to all tenders. So that's where we got the concept of the R-wind tenderer from the SIAC case. And then going on to the next case we wanted to just talk to you about today, which is healthcare at home. So much later, 12 years later, in 2014, and this is an interesting sort of angle on how the R-wind tenderer test is applied by the courts in this country. So the facts here were quite simple. The healthcare at home was an incumbent supplier who was unsuccessful on a re-procurement for the supply of medical services to Scottish authorities. And they said that the reason they lost was that they had misunderstood the award criteria, so they sort of didn't give what the authority had asked was wanting, but that was because the criteria hadn't been sufficiently clear. And indeed, it produced witnesses to the court to really sort of set out in full detail how it was they'd come to misunderstand this. And their argument essentially was that because these witnesses had misunderstood it, this sort of itself proved that the R-wind tenderer test could not have been met. Because if it had have been met, then of course there would have been no room for any misunderstanding. And the courts didn't like that argument. So the first instance court didn't agree with that approach. Healthcare at Home then took it to the Court of Appeal, who also didn't agree with that approach either. And then it went all the way to the UK Supreme Court, who sort of continued to disagree with them. And they said that what the court does when they are applying the R-wind tenderer test is to look at the matter objectively and rather than hearing evidence of what was actually the experience of tenderers in the actual procurement. And in fact, as I say at the end there, the evidence as to what the tenderers themselves actually thought is essentially irrelevant. So that's sort of a helpful angle, that it really shows and cements the idea that this is an objective test, and the courts will form their own view of what the R-aligned tenderer would make of the ITT. So just a few lessons we can learn from the cases. Clearly very important to disclose your criteria in the contract notice, and to make sure you write them down in such a way that at least it's objectively possible for an online tenderer to understand and interpret them in the same way. But that there are limits to how far you have to go. You don't need to prove that there was no divergence in how individual tenderers understood the ITT. And you don't need to frame the ITT in such detail so that two reasonable people couldn't possibly ever have understood it differently. And nor do you need to sort of drill down into the absolute most minute detail so that there can be no room for any variance in how people understand the award criteria, because the courts recognise that there is a limit to what is possible. So that's the online tenderer. The next lesson is around clarification, and I think Claire is going to come online and talk to us about that. Thank you, Claire.
Thanks, Jenny. So this is probably one of the largest areas of confusion in procurement law. And if you can just go to the next slide, Jenny. The first question we get asked is, well, are we actually under a duty to clarify tenders? And as was established in the case on the screen there, Hersey, yes, you can actually be under a duty to clarify in certain exceptional circumstances. And in Hersey, the court established some principles, some guideline principles as to when to know when you might have to clarify something. And the first one is where the tender is ambiguous, but it will not actually amount to a duty in every single case. You need to follow the rest of the test in order to establish whether you have to clarify. The second one is where the terms of the tender itself and the surrounding circumstances indicate that there is potentially a very simple explanation. It might also arise where if you don't clarify, it could amount to a manifest error. And it will not arise where any clarification or amendment would in reality allow the bidder to resubmit their bid or give them an extra opportunity to basically rewrite their tender. Just moving to the next slide, please, Jenny. Firstly, looking at one of those bullet points there, does it relate to a matter which has a simple explanation? And helpfully, there is an example here in case law. So in Tideland, this was a very simple error which a tenderer made. Basically, the tender deadline had been extended at the request of one of the bidders in the competition, and all bidders in the competition had to write a statement to accompany their tender, which said, my tender is valid for 90 days from the submission deadline. Because the deadline got moved, one of the bidders in particular hadn't amended the date, which was 90 days after the amended deadline. And for that reason, the bidder was excluded from the procurement. Looking at the next slide. So basically, if what the court said in Tideland was if the error or omission is that simple, it could amount to almost a manifest error not to clarify. It had a simple explanation, and basically it was an arbitrary reason why this bidder was excluded. So if you come across something as simple as that, you could actually be under a duty to clarify, and excluding that bidder could result in a successful challenge. A question we also often get asked is, can we allow a bidder to supplement its bid after the deadline? And the leading case in this area I would advise you to look at is Manova, which establishes some guidelines really as to whether you can actually go back to that bidder and ask them for that additional information, or allow them to submit their bid after the deadline. In this particular case, it was basically a couple of balance sheets that were missing. And what the court said was, because those documents predated the tender deadline and your ITT left enough flexibility for you to go back to bidders and clarify, you can allow those bidders to submit those balance sheets. it's in contrast, in Leadbitter, a significant amount of the tender was actually missing at the tender deadline, and in that case the court couldn't come to the conclusion that it wasn't basically allowing the bidder an extra opportunity to write their bid. It would have amounted to unequal treatment. So in that case the court decided it was right to exclude or to not allow that bidder to submit that additional information after the deadline. Move to the next slide, thank you. I think the important thing to remember when you're thinking about clarifications is the guiding principle of equal treatment. And I've put the quote from Fabric on the screen there, because often this can be confused. Equal treatment doesn't mean treating everybody the same way, no matter what the situation is. What Fabricom established was that bidders will be in different circumstances. There's no one size fits all. So each case might have to be treated differently. And strangely, that constitutes equal treatment. So it must always have regard to applying that equal treatment principle properly and not in a very rigid way. Otherwise, again, you could find yourself in a challenge scenario. Just moving on to the final slide, I've just put a roundup there of the lessons you can learn from those cases. I would say if you get asked questions on clarifications, can we clarify, can we go back and allow this? These cases are actually really helpful for you to refer to and hopefully give you some armoury there really to speak to your colleagues. I won't run through them as we've already gone through the cases and time is ticking on, but hopefully that's a helpful takeaway for you. Thank you.
Thanks, Claire. Morning, everyone. So I'm going to look at lesson 3, which is how to conduct a robust evaluation and moderation process. As the quote on the slide suggests, evaluation is a solemn exercise of critical importance, which demonstrates an authority's compliance with the procurement regime. We also want to make sure that we're demonstrating value for money for the taxpayer, and in turn securing the buy-in of stakeholders and passing governance. We also really want to make sure we're avoiding headlines like these. I was very proud of myself with that animation. These are real headlines from recent years that go some way to show the importance of the evaluation process, and it's fair to say that evaluation generally is the subject matter of a lot of procurement cases. Just moving on to the next slide, a key component of ensuring a robust process is making sure that your evaluators understand what their role is. It's worth reminding evaluators of their obligations under the rules and the fact that their notes and decision making is disclosable in the event of a challenge. As part of the onboarding of your evaluators, it's a good idea to have a conflict of interest process, of course, but also make sure that evaluators remember that they are to be impartial, so not to demonstrate any bias when evaluating tenders. So writing things like, we worked with them on the previous project and they were terrible, that sort of thing is not advised. Secondly, consistency is very important. So making sure that evaluators don't compare bids. I think we had a live question on that point. Consistency also means that evaluators shouldn't score one bid more favourably or more harshly compared to another. And another sort of related point is making sure evaluators have enough time to do their job thoroughly. Sometimes you can tell what time of day evaluators have been evaluating by the notes, as they tend to sort of trail off towards the end of the day. So making sure evaluators do have enough time to do their job properly. Confidentiality, of course, is very important. So that means not discussing the evaluation process with fellow evaluators. That's to come in the moderation session, not to discuss with other members of the organisation, and of course with any third party. Technical competence is really important as well. So it's important to avoid the sort of bums on seats mentality and make sure that your evaluators understand the material they're being asked to look at. They understand the requirements of the tender, so that they're able to give a credible justification for their score. I'm going to save notes for a bit later, so I'll talk about that in lesson 5. Just a quote from the NDA case. So this was a big dispute relating to the procurement of decommissioning of a number of nuclear facilities. The dispute resulted in a public inquiry, significant damages, and also a hefty 240-page judgment, which set out all the procurement issues. Ultimately, in that case, the court held that the successful bidder should have been disqualified had the evaluation criteria been properly followed. There are a number of errors with the evaluation process. The quote on the slide might arguably sort of state the obvious. A good way of ensuring a robust process is to set out a clear evaluation methodology, thinking about all those principles that Jenny outlined earlier, and then follow that evaluation methodology and apply it in the same way for all bidders. Just before I hand back to Claire, just a quick word on moderation. So the purpose of moderation is to iron out inconsistencies in the score, in the scoring, in order to come to an agreed score for each criterion. Lancashire Care is one of the key cases in this area. The incumbent tenderer was unsuccessful. They lost out with a margin of just over 4%, and the unsuccessful tenderer alleged lots of manifest errors, which Claire will come on to talk about what a manifest error is. The moderation process was really problematic. The court found that there was no real comprehensive discussion of the evaluators' individual scores. So it was really difficult for the court to see a clear line of reasoning for the agreed scores. The council did have its own internal guidance on moderation, but that was ignored. Evaluators were sent emails asking for their acceptance of the moderation process, but it wasn't clear that they'd actually seen the notes that they were sort of agreeing to. So what can we learn from these cases? Just on to the next slide. So training your evaluators in advance is really key, and making sure you leave enough time for your evaluation as well. As we've also mentioned, a lesson coming out of the NDA cases, don't encourage your evaluators to lean against disqualification. So really important that you do as you say you were going to do. Back to Claire.
Thanks, Shailee. So now we're going to look at what's the difference between manifest error and the margin of discretion. So if we could just move to the next slide, please. The most quoted case by the courts in this area is Lion Apparel and Firebuy. And this is actually quite a common ground for challenges, and it's important perhaps from both an authority side and a challenger side to understand the difference between these two concepts. And what the court established in Lion Apparel is that in related of matters of judgment or assessment, there is this margin of appreciation when evaluators are applying scores. And generally speaking, the courts are reluctant to interfere with that margin of appreciation, that margin of discretion, and they will only do so if it's what is called a manifest error. And essentially what this means in plain English is it's a really obvious mistake, and it can be quite a tricky element to prove from a challenger's perspective, but it happens it's very common that this can happen, and there is a lot of case law, as Shailee says, with a leading one there being Energy Solutions. So it can happen every day in evaluations. Just moving on to the next slide, please, Jenny. Case law has given us a lot of examples of the type of things which constitute a manifest error. And Shailee's already talked about Energy Solutions there. And one of the examples in that judgment was scoring up to avoid exclusion of bidders because there was a minimum scoring threshold. So clearly doing something like that would constitute a manifest error. Excluding a bidder on the basis of a pass-fail criteria, but not making clear that a fail means exclusion. This actually happened in the MLS case. There were pass-fail questions, but the Secretary of State for Defence didn't actually make it clear in the tender documentation a fail means exclusion. You'd have thought that would have been obvious, but actually the court on this occasion decided not. You need to be very clear if something is going to result in exclusion. Incorrect application of the scoring criteria. Again, Shailee will talk about that. Again, just a very classic example of a case of manifest errors conducted in the evaluation process. Misunderstanding the response. We've had a recent case, brace yourself, where much of the judgment talked about the difference between a stair lift and a stairmaster. And because the evaluation panel misunderstood what a stair climber was, this actually had a massive impact on the scoring in the process, and the court came to the conclusion that this was a manifest error. Ignoring a key requirement. So there is a European Ombudsman case there where basically the winning tenderer hadn't got some of the accreditations which were expressed as minimum or mandatory accreditations, and that was obviously a manifest error. The abandonment of a procurement exercise. Now you might query what's that got to do with manifest error, but this was brought up in the Ryehurst case, where the court actually said if the reason why you've abandoned is irrational, again going back to some of those fictional concepts Jenny was talking about at the beginning of the webinar, it could be a manifest error. In this particular case, the court decided that the reasons behind the abandonment of the exercise were fairly legitimate. It was due to the contractor being involved in the Grenfell construction, and therefore losing the confidence of stakeholders essentially. And in that case, the judge says, well, this was a perfectly rational reason to abandon this procurement exercise, and therefore it could never be a manifest error. But something to think about, because it's not necessarily something you would think would be a manifest error, abandoning a procurement process. Failing to exclude an abnormally low tender, again, something you wouldn't think would be a manifest error. And I would say that, generally speaking, challenges based on abnormally low tenders are notoriously difficult for a challenger to pursue. But what the court did say in SRCL is if you think something is, if a bid does look like it's abnormally low and you've identified that, but you fail to do nothing about it, that could be a manifest error. In this particular case, that didn't happen, but again, worth bearing in mind. Just moving to the next slide. These aren't examples from case law, but they are examples we have seen when reviewing documentation, acting for challenges and defending challenges, and things which we think would most likely be considered by the court to constitute manifest errors. We see this a lot, scores being awarded in the standstill letter which don't actually tally up with the scoring scheme. And we think sometimes that might happen where the moderation process has produced an average score, but the ITT didn't say that was what was going to happen. So that could be a manifest error. Taking an average where you haven't said you'd take an average, again, could be a manifest error. Awarding a pass for a pass-fail question and vice versa. Again, we've seen that happen. And excluding a bidder for being abnormally high. Seems a bit, might be a new concept to some people, but we have actually seen this. But unless you've explained that you have a maximum budget or an envelope which the bidders have to meet, you cannot exclude a bidder where you haven't made that clear, and that could be a manifest error. So just a quick note on, there is no margin of appreciation when it comes to complying with the principles of transparency and equal treatment. The court will always look at that in a very plain way. Has there been a breach of transparency, and is there a breach of the equal treatment principle? So there's no margin of appreciation when it comes to those types of breaches. And finally, I've just put on the slide there some of the key lessons you can learn from case law. Just to quickly go through a couple of them. The key thing I would take away from this is follow the process you said you would follow in the procurement documents, and that should get you most of the way when it comes to defending manifest error allegations. It's surprising how many authorities don't actually follow the process they've set out, and that's what leads to a lot of challenges. Okay, I'll now pass back to Shailee. Thank you.
Thanks, Claire. So the final lesson is on note keeping. So really important that authority has adequate contemporaneous evaluation records, and those records need to document the scores and the reasons for the scores. Often the standstill letters or feedback letters that are drafted will come from the evaluation materials, and without robust and comprehensive sort of base material, it's very difficult to draft compliant letters. The other point on the slide is that if a procurement is challenged, as I said earlier, there are extensive disclosure requirements, and the court and the other side will need to inspect exactly how the evaluation was carried out to ensure that the ultimate contract award decision was justified. The lack of adequate note keeping has been a reason for finding a manifest error in previous cases. So one of the cases that Claire mentioned, Woods and Milton Keynes, in that case, it was an incumbent provider, again, who was unsuccessful and challenged. The court did say that the lack of contemporaneous records on the evaluation process was one of the reasons for setting aside the decision. There were 3 separate stages of evaluation, and the scores were changed each time, but that generated almost next to sort of no contemporaneous documentation to justify those changes. The court also commented that the notes that did exist weren't very helpful, as they paraphrased the scoring criteria rather than explaining the reasons why a response did or didn't meet the requirements of the question. That case was notable because the court looked at tender submissions and undertook a rescoring exercise. So the court reduced the score awarded to the unsuccessful. This court reduced the score awarded to the unsuccessful bidder by 40 marks and increased the mark to the successful bidder by 6 marks. And the impact of that would have been to sort of flip the award decision in favour of the unsuccessful bidder. Just moving on to the next case in the final few minutes, this was the Lancashire Care case that we looked at earlier. Another point, a key point of that case, was the material that demonstrated the moderation exercise. The court said that the evidence showed that the additional information was added to the moderation notes after the event, and it was impossible to identify what was truly discussed in moderation and what was added at a later date. The court also found that the moderation notes had conflicting points, and it wasn't clear to see what clear process was followed. While a template did exist, it wasn't followed, and the lack of clarity in record keeping was a reason for the decision to sort of set aside the contract award decision. So a lot does really depend on the sort of paucity of those notes. So what can we learn from these cases? I think ensuring that you've got a clear audit trail of the evaluation and the moderation exercise is really important. It's sometimes possible for scores to change during the evaluation process. I think we've seen lots of moderation processes where following discussion scores do change, but what's really important is that you capture the reasons for those changes. And also elaborating on the scoring criteria when you're giving reasons, so bidder specific reasons for why a score has been awarded. Authorities should also encourage evaluators to retain their note taking, so don't apply defensive approach to note taking. So another point from the NDA case was taking a defensive approach, so limiting the amount of notes that evaluators could make, and also shredding notes as well, so definitely don't do that. I think that's all from me, so back to Jenny.
Thanks, Shailee, and Claire too. So I think that's all from us for today. Please do look out for our follow-up email, so which will have a recording and a copy of the slides and our Q&A response document. If a feedback form pops up, we're really grateful if you could complete that. And do look out for the invitation to our next webinar, which I think is on the 9th of November. But in the meantime, thanks very much to you all for joining us, and enjoy the rest of your day. Thanks, everyone.